I don't say this lightly, but the understanding that you have of your office and your responsibilities, I find to be completely at odds with what I understand your responsibilities are. In particular, what is a plain violation of two executive orders by the mayor, which specifically removes the law department from interposing its view of what documents and information are necessary for the Department of Investigation to conduct a proper investigation. So let's start with those executive orders. Executive Order 16. The Commissioner of the Department of Investigation shall have authority to examine, copy, or remove any document prepared, maintained, or held by any agency, except those documents which may not be so disclosed according to law. Every officer or employee of the city shall cooperate fully with the Commissioner and the Inspectors General. Interference with or obstruction of an investigation conducted by the Commissioner or an Inspector General shall constitute cause for removal from office or employment or other appropriate penalty. Drilling down on the specific circumstance that occurred in the Rivington investigation, Executive Order 105, the Inspector General shall be informed and have unrestricted access to all regular meetings of agency executives and managerial staff, and to all records and documents maintained by each agency. Unrestricted access. Nonetheless, in the course of the Rivington investigation, the Department of Investigation was compelled to title a section of its report, quote, "Lack of cooperation during the investigation," and then enumerating several instances where, in their terms, contrary to Executive Orders 16 and 105, they were denied the unrestricted access which is required by the executive orders. We've been dancing around the subject, but it has to be made plain that the analogy of your protecting the city's interests from some outside investigatory agency, whether it's the U.S. Attorney's Office, the DA's office, the Attorney General, it's hard to keep track, is inappropriate. This is a city entity, the Department of Investigation, charged generally, and in this case specifically, with investigating what happened with Rivington. The analogy that you make or suggest, it doesn't fit. A better analogy would be a corporation finds that there's been some wrongdoing within the corporation. They charge their general counsel, or they hire outside counsel to conduct a thorough investigation. It's inconceivable in that scenario that some other lawyer or some other department within that corporation would put itself in between the investigatory efforts of the firm that was hired or the general counsel. That's the analogy here. It's what struck many of us as shocking, and the mayor's own commissioner of investigation, or the department, because the commissioner had to recuse himself because of his prior political relationship with the mayor, itself called the law department, and by extension the rest of the administration, to task. So I don't understand what authority you're asserting to interfere and deny the, quote, unrestricted access which the mayor's executive order requires. Can you identify that authority?
Oh, absolutely. Actually, to some extent, you've already read it. First of all, the executive order cannot invest in the Department of Investigation or any other institution more authority than is granted by the charter. The executive order amplifies that authority, it clarifies that authority, it doesn't confer any new or broader authority. The charter gives access to the Department of Investigation of every scrap of information they need to fulfill their responsibilities to conduct investigations under the charter. All right? But the key word is necessary to fulfill their responsibilities within the scope of their authority. And that is a determination that is made investigation to investigation.
Respectfully, I have to interject here, because the determination as to who is going to determine relevancy and scope and appropriateness was decided through these executive orders to be in the hands of the Department of Investigation.
Correct.
So it's not, the phrase unrestricted access and the rest of the language of the executive order takes from the law department what in the ordinary course of some external investigation would be your responsibility to determine relevancy, privilege, and all the other things that we lawyers love to argue about. Takes it out of your hands and puts it in the Department of Investigation.
That is, in my view, not true. And what you're conflating are two things that are different, even though the different is somewhat subtle and intangible, but it's an important difference. And it's the difference between who determines what's relevant. There's no question that the sole determinant of what is relevant and responsive is the Department of Investigation. They declared what they considered to be relevant and responsive when they served on the council for the mayor their first request for documents. It is very specific. It is well done. It lays out all the things they need. What we're now talking about, and lawyers quibble about these things and negotiate these things out in the course of these kinds of investigations and requests for production of documents all the time, is the manner of production. Not what will be produced, but the manner of it. The standard way this is done, and you are a practicing lawyer, so I know you know this, the standard way this is done is the way it was done. And that is that they gave us a roadmap of what they considered to be relevant materials, and we applied the kind of search term technology to these databases that it was calculated to produce that. And after the fact, because of the claims that they made in that section of the report that you have cited, in order to provide publicly, and we actually did this with a press release, as you'll recall, on July 27th of this year, in order to make it clear publicly that nothing had been withheld that was by way of responsive documents. We gave them unredacted versions of all the documents that it provided.
The Department of Investigation, when it enumerated the various ways in which you did not cooperate during the investigation, one of those was that calling material in the documents not responsive. And in one such production from the Department of Law Department, DOI received approximately 1,000 documents, approximately 990 of which were blank pages containing the letters not responsive.
Absolutely.
Now that would be appropriate and usual and standard practice as between two adversarial parties. But contrary to what I'm understanding you're saying or what I'm hearing, you're making a determination as to what's relevant and responsive, and what I'm saying is the plain reading of the executive orders is that it'll be up to the Department of Investigation to make that determination. And we wouldn't be here except for the fact that the Department of Investigation was troubled by your determination of certain things as being non-responsive. So
actually, that is absolutely and unequivocally not true. And maybe I haven't stated this clearly enough. The Department of Investigation, before we provided the unredacted, the 5,000 pages of unredacted documents, made a claim speculating that there may have been, masked by our redactions that were labeled NR, non-responsive. There may have been responsive material withheld. That is absolutely, positively, unequivocally not true. We've now provided the unredacted documents, and there has been no claim that anything was held back.
DOI was not correct when DOI wrote, in one such production,
Yes.
DOI received approximately 1,000 documents, approximately 990 of which were blank pages containing the letters NR for not responsive.
Yeah, well,
False?
can I describe to you what that document was? It was a directory of healthcare facilities. And it's a directory, it's like a phone book of healthcare facilities. And Rivington was mentioned in only, 10 pages? It was mentioned 5 times in this 1,000-page document. And so consequently, and here's, listen, nothing's perfect. When you are trying to respond quickly as you can, to a request for documents contained in a massive database, there's some things that get done mechanically. All right? If we had to do all over again, if it's basically a phone directory, we might have sent it over and said, oh, by the way, just so you don't waste your time, right, reading 1,000 pages unnecessarily because we know your time is valuable, we'll give you this and we're going to tab the pages and say Rivington is referred to on these 5 pages.
I get it, but
instead, as is done in the course of a massive document, it was done in the way it is typically done, and that is that you apply, some clerical person, under the supervision of a lawyer, has identified where the responsive materials are, and they've blanked out the rest. We could have done the opposite, and for that particular document, it would have saved us some mischaracterizations of what we've done.
Respectfully, and this is my point.
Yeah.
You should not have done that. You should not have engaged in this exercise where you made a determination whether or not Rivington's mentioned 5 times or 10 times or 3 times is enough to satisfy the Department of Investigation's demand for responsive documents. The executive order. Look, you and I are used to how the balances of these of the discovery process has been determined in a civil proceeding or in a criminal proceeding, and the arguments that you're making and explanations that you're giving are perfectly appropriate and correct in those proceedings. My point is, in a Department of investigation, certainly within the executive agency, those balances have been struck differently. And that's what the executive order represents. There's nothing in the federal rules of civil procedure or criminal procedure that comes remotely close to what we read in the executive order. And so you're applying a standard that doesn't fit these investigations. That's why the Department of Investigation...
I understand that's your view. I believe that is not a fair reading of the law is in context. Because the broader context is the charter. The executive order are the mayor's rules. They are not law, they are the rules that amplify and explain and clarify that certain provisions that are or authorities that are created by the charter. And I think you should agree with me that while the Department of Investigation is entitled to access to all information, and I mean all, necessary to conduct an investigation, they're not entitled to have information that's not necessary to conduct its investigation. Having broad authority is not the same as having unlimited authority, and I understand you cited to the federal code and the Constitution and other information pursuant to requests or demands in other contexts. And I understand that there are things that distinguish them, and I understand that the executive order issued under Koch and not amended thereafter significantly provides a substantial amount of latitude and access to the Department of Investigation. Where I differ is that there's an important distinction between having unlimited access and having necessary access. It is the broadest possible access that permits DOI to do its job, but it is not without limitation. There's a limitation of relevance.
Let me conclude by saying the description of how the law department made determinations about what to produce or not to produce is indistinguishable from the process of an ordinary civil litigation with adversaries. And that your view of the Department of Investigation's authority and the interpretation of the executive orders is for all practical purposes to eviscerate the effect of these orders. That is why the Department of Investigation itself, not the council, the Department of Investigation itself was disturbed enough to include it in its report, and why, after I wrote a letter to the Department of Investigations, they threatened to take the administration or you to court to enforce its right to this material. And I would urge you, going forward, to really reconsider a position that has the effect of eviscerating these executive orders, which were designed to give a quick, expeditious, and transparent authority and accounting and investigation of potential wrongdoing within the administration, by the administration. Thank you.